Welcome to the Writer's Bridge, and we invite you to go ahead and put into the chat, that's over on the right-hand side there, put into the chat, where are you coming in from? What are you working on? And do you have any questions about copyright, AI, plagiarism, your rights to your work, other people's rights to your work, all that good kind of stuff? We are going to be taking questions as we go. And just so you know, Sharla and I will use the question icon to mark your question with a question mark. So feel free to heart and thumbs up and respond to each other by all means. Share information, ask more questions, but leave that question mark icon for us so that we can find your questions. If you are active online, you may have noticed my essay on the Brevity blog last week about writing with AI. You may also have seen the 298 comments on Blue Sky calling for my intestines, decrying my obvious lack of writing talent, or one of the lively discussions on Facebook about my destroying the environment, stealing from authors, and apparently kicking off the literary apocalypse. I also got quite a few emails, but other than a couple of FUs, what I mostly got was writers saying how AI had helped them navigate their ADHD, edit their own work, or write marketing materials so that they could focus on their creative writing. And every one of them said they were afraid to speak publicly about this. And I don't blame them after being yelled at by people who know me, people who know my work, who have met me in person, and who are generally my colleagues. Maybe they're not anymore. We'll see what happens. But even beyond AI, whether it's stealing our work, how much of the environment it's destroying, writers worry about copyright. We worry about having our ideas stolen or our pitches stolen, even by big name media outlets. And all of us have heard that writer complain that a big movie studio stole his totally marketable $1 billion idea, and we've all thought, yeah, right, dude. We worry about getting sued for writing our truth. We worry about quoting song lyrics. We worry about reconstructing remembered dialogue in memoir and whether or not we should change everybody's name. And of course, we want to protect our creative integrity and our copyright while sharing our words with the readers who need them. Today, we are going to dive into these issues with an expert. But first, hey, Sharla, what's coming up with Craft Talks webinars?
Yes, thank you, Allison. Wednesday, that's tomorrow at 1 p.m., we welcome author Jessica Handler for a timely webinar about how to write about the difficult material we often carry into our work. This is specifically for nonfiction and memoir writers. Then on Saturday this week, 2 to 5 p.m., we are going to gather for a seminar, the Self-Editor's Toolkit, led by Lisa Funderburg and designed for creative nonfiction writers at any stage of revision. You can find out more on our website, and I'll pop that into the chat. But Allison, what's coming up for you?
This weekend, I am doing Query Boot Camp. We are going to work on queries, synopses, and first pages. We've got 3 literary agents and an acquiring editor for a literary press who will be hearing writers' pitches and giving immediate live feedback on their queries. It is Friday, Saturday, and Sunday, and I would love to see you there. Every session is recorded. It is $395, but if you use the code BRIDGE, it is $295. We are giving $100 off with the code BRIDGE. Love to see you at Query Boot Camp. Hey, Sharla, who is our amazing expert guest?
Lisa Rayne is an award-winning author, an intellectual property lawyer, and an advocate for mainstream distribution of fiction and showcases multicultural protagonists. She won multiple Emma Awards and appeared on multiple Amazon bestseller lists. Her milestone historical romance centering Black protagonists, Never Cross a Highlander, garnered a coveted Publishers Weekly starred review and was lauded by Kirkus Review as a flawless combination of modern-day issues and old-school romance. And as a business and intellectual property attorney, Lisa is passionate about helping creatives become savvy entrepreneurs. Please welcome Lisa Rayne.
Yay!
Hello.
Lisa, you have stuff to tell us. We want you to kick it off. What is important right now? What are you thinking about in the world of copyright, plagiarism, and AI?
Well, thank you, first of all, for having me be here. And I always start these things with just the basic definitions of the three items we just talked about: copyright, trademarks, plagiarism. Because often what I find is when I see creatives talk about this online, they're overlapping concepts. So we're talking about the same terminology here. Copyright protects original works of authorship fixed in a tangible medium of expression. So what that means is it has to be in some fixed form that other people can actually see, interact with, or understand. So idea is in here. A scene from a book is on paper and in words. That's tangible. So that's what we're talking about. Trademarks are slightly different because they protect brands. So a logo, while if it's creative enough, can be protected from how it looks as copyright, to actually serve as a trademark, it needs to distinguish the person, company, or whatever business is actually distributing the product. It is a way to delineate quality, or so that people know who it's coming from. So when I buy Nike shoes, right, I'm going to expect quality I've come to know from the company Nike. If I pick up something with the Nike logo on it and it falls apart after my first track meet, I'm upset, and it no longer has that quality or that goodwill I was looking for from Nike, right? And I'm going to be mad and sue. Now, if you bought knockoffs, right, Nike's now mad and is going to sue because the knockoffs weren't of their Nike quality, and now you've damaged their brand, their goodwill. That's different than copyright, but people use them interchangeably. I'm going to trademark this idea. I'm going to copyright my brand. You can't, right? They're two different things. Then we get to plagiarism, which is the practice of taking someone else's work or ideas and passing them off as your own. So that means you've not given them citations, you've not given them any kind of credit. So one of the easiest ways to think about this is think academic writing. When you get to academic writing, whenever they espouse a theory, theme, or data that came from someone else's works, they're going to give you footnotes, they're going to give you references, there's going to be some kind of citation or annotated bibliography associated with that. It's the same concept, actually, when you're talking about someone else's creative works. If you're talking about or getting the concept from someone else, give them credit for whatever concepts are coming from their work. If you're only talking about the idea, it's
Oof.
not plagiarism, okay? Ideas are not protected. So going back to copyright, original works of authorship in a tangible medium of expression, copyright doesn't protect ideas. So I don't know if many of you are on Threads. I mainly lurk and post every once in a while, but I saw a couple months ago the big thing blew up between authors of works where the heroine got her power from the sun. And one was a new fantasy debut coming out, and she was advertising her book on Threads and Instagram. And another author said, "That's plagiarism. You've copied my work. Cut it out. I'm going to sue you," because they had a book in which the hero got their power from the sun. And I thought, you've got to be kidding me, right? Because does anybody else happen to know a hero that's been around for decades that gets his power from the sun?
Yes, yes.
Anybody heard
He
of
hangs,
Superman, right?
yeah.
Or, we can go a whole lot further back than that. We've got Greek and Roman mythology,
We've
right?
got West Side Story
Heroes.
and Romeo and Juliet.
That was going to be my next thing, right? It's like, it's not plagiarism. The concept of warring families and star-crossed lovers, right, goes back to that, but it's an idea. So I just want us to be careful when we're talking copyright, trademarks, plagiarism, that we're talking about the right vocabulary, the right vernacular. Then we've got AI. Woo, oh my. I was admitting to Allison and Sharla earlier. I've dabbled with it because I'm curious, but I'm not a big AI user, and I'm not a big fan of AI in the creative space, only because I've watched creatives year after year after year have the rights and what we can protect as creatives get diminished more and more and more each year. And so right now, copyright law is if it's generated by AI, it is not protectable by copyright because it is not created by a human. There are several suits right now challenging that says I spent, lots of time, hours refining my prompts to the chat, making it make changes. And because I made 300 or 3,000 edits to this, I am creating it because of the amount of curating I did to my chats and my prompts. I'm watching those closely. Honestly, I'm hoping they don't win. We can talk about that during the Q&A. But the more we say this technology can replace what we do, the harder it is in the future to have copyright protection for a lot of creative works. There are people who are actually beginning to argue that copyright protection should be done away with. And I think AI in the future will be one of the technologies used to help bolster that argument. So I just think we need to be careful what we say it can and can't be used for, and just know it's not subject to copyright protection. So if you're doing your covers using AI, know that anybody else can take your cover and use it because right now copyright law says it's not protectable by copyright. So if you ever worried about having the same cover as somebody else, know that that's now just fair game. We'll see if it changes, but right now it's fair game.
Wow, that's a lot to think about, Lisa. We've got questions for you, and we'll also be taking questions in the chat. Writers, we use the question mark icon to tag your questions so you can find them. So please upvote with a thumbs up, but please do not use the red question mark, please.
Lisa, I hear a lot of writers worried about their actual material. Memoirists ask me all the time, can my angry ex-husband sue me? Can my angry mom sue me if they write a memoir? Is that an actual risk? Are they likely to A, be able to sue, and B, be able to win? And how can we guard against that? Because even if they can't win, it can still be really unpleasant.
I like that you said A, can they sue? And B, can they win? Because my first answer to can I be sued questions is yes, absolutely, anytime for anything, especially if you happen to be an author in America. In America, we are litigious and Americans sue over everything. And unfortunately, you can usually find a lawyer to take the case, regardless of whether or not the law says it's probably winnable or other people think it's winnable. So if you write a memoir, yes, you can be sued. Yes, your ex can sue you, whoever can sue you. Now, can they win is another question. And I'm going to divide that into two answers. One of the answers is can they win will depend on the facts and the law. And memoirs are touchy because if what you write is true, truth is an absolute defense to any kind of libel or defamation, if you're saying it, suit. In memoir, however, we're often recapping experiences that we are talking about from memory. So unless you have secondary proof that what you're saying is true, it will often come down to how they remember the experience versus how you remember the experience, which will be a fight in court. The other thing to be concerned about is can they win, is who's got the deeper pocket. Unfortunately, in the US, litigation is not just about who actually has the best legal case. It's often who has the best lawyers and who has the deepest pockets because there's motion practice, there's discovery, there's all kinds of things that can be done to drag it out, hoping that your opponent, your adversary, runs out of money. And
Mhm.
in that case, even if you're right, legally and factually, you may lose just because they outlawyer you. And it's unfortunate, but that is the way our system works.
Right, and you're talking specifically about America, not the UK, for
No,
example. Right,
correct.
right. Should writers register their copyright before querying or sending out their manuscript, or what if they self-publish? Is the inherent automatic copyright enough, or does registration help with potential issues? What do you think, Lisa?
I think you should register it before you publish, definitely. Whether or not you register your copyright before you pitch, um, is up to you. And there was a time when I would have said it's not as important. Unfortunately, we've seen several cases in the last 5 years or so where it has become clear that an agent or editor took a concept they got from somebody else's book and gave it to a writer whose writing style they liked better. In many instances, there's still not a copyright infringement for that if they just took the idea and said, "Ooh, I like this idea of um, individuals who fight with dragons instead of fighter air, airplanes." But some of these cases, we've got same names, same weather during the scene, same, right? And if you have registered your copyright before those instances, then things like statutory damages kick in.
Mm-hmm.
And I think statutory damages are really, really important in an environment where so much stuff that goes up online or on sites, they say, well, I did it for free and I'm not making any money off of it. So then when you sue for copyright, there's no damages because they didn't make any money.
Mm-hmm.
However, with statutory damages, they don't have to make money. The copyright law sets a fixed fee per infringement of the work that you can get regardless of whether or not the person made money. So, statutory damages you're going to want when you publish. Because if you put it up online and you put it on a pirate site and you actually can find the people who own the pirate site, which is a whole other question, right? Then they still have to pay you even if they were giving them away for free.
Mm.
Um, when it comes to authors and editors, ethically they shouldn't be doing that, but unfortunately, we're finding that more and more people are not following what used to be just considered daily practice in a creative space. So if you have a finished manuscript, there's no reason not to file for copyright as an unpublished work and then file again once you actually publish it as a revised version of that work. But
Mm.
that can get expensive if you are querying. Some people
And
write 5, 6 manuscripts, but
and usually authors typically focus on the fact that all of our work is considered under copyright from the moment it's created. We can't sue for statutory damages, but it is copywritten.
right.
And most of the time, what protects authors is that our work is our enemy is not piracy, but obscurity. Most of the
Ah,
time, nobody wants to steal our work because if you think about most publishing scams, oh, pay me money. I'm going to pitch your movie to an LA producer. Pay me money. I'm going to make a book trailer for you. If they steal your work, who is going to pay them?
mm,
So authors are generally not too much at risk of having like their actual whole manuscript stolen. But I want to jump on the thing that Lisa said about agents and editors sometimes getting caught giving somebody else an idea. There was a case recently in the last 6 months where an agent got fired because she said on Twitter, I had a great pitch come into my inbox, but the writing wasn't there, so I gave it to another author. And people were justifiably outraged, and plus I would say too, if you're good enough to write your own book, you're good enough to come up with your own idea. Lisa, I've seen many writers who have pitched a media outlet and then they've gotten a no, and then they've seen the outlet publish a very similar story. And most of the time, these stories were already in the pipeline because ideas related to culture and news are likely to come up for more than one person. But recently, I heard from a writer in our community who had pitched a very specific, narrow pitch to a major media outlet with a one-of-a-kind expert source. The media outlet said no. And then the writer got a call from the source who said, hey, I just got asked to interview. The media outlet was planning to write the pitch that they had said no to with the writer's expert that she had sourced in their story. What would you advise that writer to do, Lisa?
This is going to hurt people. But as I said at the beginning, copyright does not protect ideas. So if you pitch an idea and an outlet likes the idea, but chooses to go with someone else, there is no infringement there. So we talk about, but is it ethical? Is it any of these things? There was a time where I think we could say it's unethical and people just shouldn't do that. But now that we are deep in the Google and the online database generation and you can find anything online almost for free, the concept that ideas are free to use however you want is becoming ubiquitous, especially in the US space, but even a international copyright ideas are not protectable. So unless you have some kind of written contract that says, I'm going to pitch you these ideas and you have to agree not to use them for, say, 5 years from the time I pitch them or whatever, you can't stop them. And if you are a small or unknown writer, nobody's going to sign an agreement, an NDA, or an agreement not to publish with you. If you're a major writer, like John Green, if he's going to pitch something to the New York Times, he could probably get the New York Times to sign it because they want John Green bad enough. But most everyday writers don't have that clout. And if you're going to pitch it, it's a double-edged sword. If you're going to pitch an idea to win, you need to give them a lot of information. But I warn people, pitch only what you have to pitch to give them the concept. So for instance, I would never put the names of my sources in my piece because now I've given them not just the idea, but I've given them my research and my contacts, which allows them to do exactly what they're going to do. If they're good, they may find my expert anyway, but at least make them do the work. So to the point that you can pitch without giving away all of your contacts, all of your research, pitch the idea, not your research. And it's a fine line to walk, but to the best that you can do, that's what you have to do to make sure you protect yourself as much as possible.
Right.
And so instead of saying, I will interview Dr. Bob Ross, who is an expert on painting happy trees, you would instead say, I will be interviewing an expert on the painting of trees who will have exciting information to give. We have a couple of people weighing in the chat to say that they have found that stuff got stolen. Morgan says that a company, a magazine took her pitch and gave it to somebody else. When she called them on it, they did give her a finder's fee. So it can be useful to write to that editor and kind of put them on notice. And, you say it politely and you say, gosh, I know that a lot of ideas are common out there, but this seems very, very close to my pitch. And it sounds like you're moving ahead. I'd like to go ahead and arrange a finder's fee with you, or I'd like to be assigned as the editor to this, that you're the author of this, that you're moving forward to. You may not get anything from them, but at least it puts them on notice in a little tiny way.
Yeah.
I would also add to that, it's great that she contacted the editor and said that. The other thing I'm going to add, which is going to be a little controversial if you are on the corporate side of this, but creatives, writers, journalists, whatever, keep being silent. There was a time where these things happened and you were supposed to be silent and take it and not share it. which allows corporations and individuals in those positions to keep doing it because nobody knows.
Mhm.
But I now feel that if X magazine, X newspaper is constant, or X editor is constantly in the habit of taking people's pitches and giving it to somebody else, it's time creatives publicly say, I pitched this idea to X. And rather than hire me, they took my entire story, contacted all my experts, and wrote it with someone else. Are you going to get any money out of that? No. But putting publicly the names of those people out in the sphere, it warns other creatives, and most people don't want people to know they're doing this. So they will be a little more careful. Some of them, if they're bad actors, they'll be more sneaky. But some people legitimately feel they can do it because they're never called on it. So we have to start sharing information with each other and not be silent because we're allowing our colleagues to get taken advantage of that way in our silence.
Thank you, Lisa. There's a lot of fear around AI, about machines copying original work and making generic output. We're already seeing AI write marketing and suggest slogans and taglines and calls to action for ads. Should we be worried about AI taking the place of creative writing?
Yes. I hate to say it again. I'm like, I hate to say that. But here's the thing. How good is it? Right now, it's not great. It's great for some things. I think calls to act, where it comes to calls to action for social media posts and things like that, um, it's doing a great job. I've seen a lot of people, even people in marketing, say they now when they work on calls to action, hooks and things like that, they like to run it through AI and they can get some improvements on those. And I get that. But I've also talked to several people who own marketing firms. In fact, I was just at a cookout where there was a marketing person there who says they are getting a lot fewer contracts. And definitely with some of their smaller clients, they are losing that business because they are relying on AI to come up with their marketing copy and their calls to action. So some people will lose work. I don't feel AI is at the point now that creative writing is going to completely go away. Because as I say, I there are some things it just doesn't do well, but that's yet. We don't know where it's going to go, right? They've put AI in every word processing technology you can think of just about now, and it's scraping our work. It will get better. Um, I happen to think that if you're good at it, you should still be able to distinguish yourself from creative writing by a computer. But let's be honest, some people will lose work if that's your field. I don't think it will replace true creativity, but depending on your industry, that's what they want. I don't know if you follow people at Meta or Google, but their goal is that people will adopt AI at a wholesale level across the world, which is ironic because as soon as it gets really good at it, then they'll start selling us how to work with people. But that's another conversation.
Mhm. Yeah, it's
Yeah.
everywhere. We got a lot of
Though I
questions. Go ahead,
Yeah.
Allison.
The analogy that I've heard that I think is really interesting is that CDs, to some extent, killed vinyl, and then flash drives and Spotify killed CDs. However, now vinyl is more expensive than ever, and you buy vinyl if you are a music connoisseur and you want something rare that sounds real and extra good. The same as cars came in, cars killed horses. I mean, not literally killed horses, sorry. Cars as a transportation method did away with the need for a great deal of horse drawn transportation. But now the people who work with horses are paid considerably more than the people who were paid for horses when horses was happening all the time. Now, if you work with horses, you fly to Europe and supervise a dressage competition instead of being the guy down the corner who does horseshoes. And so, Lisa, do you see any opportunities there for us to position our work as more valuable and more important?
Yes, because one of the key aspects of what is generated by AI right now is that it is stilted and that it doesn't flow and that some of it lacks voice and personality. And creatives who are into writing, your skill is that we all know how to give our work voice and we know the nuances, and as much as you can generate a initial product with AI, the beauty is in the editing, which we all knew, right? We've been doing it all manually for decades, but other people want to come up with an AI product, but it needs to be edited and massaged. So those of us with that advanced skill set, to the extent that you want to work with corporations that are going to go down this road, you're the one who's going to take that output and make it shine, make it stand out. There are some time savings. There are a lot of people who say it saves me time in that initial draft or that brainstorming or the put it right, but then you've got to polish it. And our superpower, if we're good at creative writing, is we've learned to master editing, right? And that is a skill that right now the technology can't compete with.
We have some questions in the chat. I'm going to start way at the very beginning with Joy. Joy says, I'm working on a memoir about creating an empty nest when you have a child who will never fly on their own. And I have a current Substack and older blog circling these same topics. My questions are mainly about what, if any protection ownership I have over my Substack and WordPress pieces. What can I do to enhance this? What dangers should I be aware of concerning people using my work or bits of it in ways I might not approve of? What recourse would I have if this happens? So WordPress, blog is the older one, and also currently using Substack.
It's all words. It's a literary work. It's a written work. Your blog post is a written work, and you can protect that written work to the same extent you can protect any written words by copyright. So, to the extent people are taking your idea and writing their own version of that idea, there's no protection. To the extent they're quoting you, they should be giving you credit, or else we are talking about plagiarism. So if someone is reading your blog post, like the way you said something, and then they talk about that in their blog post, they should be saying, as so and so said in their blog post X, and quoting you.
Like we all learned when we learned to write research
I was gonna
papers.
say, right? Annotated bibliography, citation, source. They should be citing your sources. If they're citing their sources, again, you can't really stop them from doing that. That's standard practice. But here's where people fall down a rabbit hole. Make sure you've backed up the copy of those blog posts someplace else, because your technology is built on someone else's platform. And if they go down or they go away, you have no recourse if they don't have a backup copy of your work, right? So the real danger is that you will lose all that work if you don't have it backed up someplace else. So back up the site regularly and keep just a hard copy on a computer drive or something, backup, backup, backup. But your protection is the same basic copyright protection of any other literary work.
We have a question from both Diane and Leah. Lee or Leah, apologies if I'm saying it wrong. If I quote one line from an old song and mention the author in my text, is that an infringement? And Lisa, what I've often told authors about using lyrics is you can't, because nobody wants to be the test case against Sony's lawyers.
And some
Where are we
people
on song
have,
lyrics?
and they've sued, and they've lost. And I'm going to say, as someone, and this is close to my heart because I initially started my career in Los Angeles as an entertainment lawyer in the music business. And so I'm often asked, how come it applies to songs, but nobody gets concerned when you do a line from a movie? And I often tongue in cheek say, because the music industry has better lawyers. But, right, I'm joking. But in essence, songwriters are very, very strong as far as both their union and their associations. So if you remember years ago, the recording industry of America went toe to toe with the Napster database that was allowing people to share music and claim copyright and things. And they banded together, they sued, they actually began suing individuals to make it stop. The music industry, if they find out, will sue. And a lot of the artists or songwriters who write their song are particular where they want their songs to be used. So some of them won't approve them to be used in commercials. So the last thing they may want them to be is in a book. So that has been litigated before. They've won, and they're an industry that has powerful lawyers and networks who will sue you. So why risk it?
Right.
Some of them will give you permission. If you want to get permission, if you've got connections, great. That's also a hard thing to get. And if you do get it, it may cost you a lot of money for that one line, but it's possible. And because there are procedures in place for you to ask for a license and permission, that also works against you because there's a way you could have asked. And if you don't, this just assumed you intended to steal. So don't do it with music.
So I have a specific question from Diana about this. I'm writing a fictionalized biography of a real life artist who passed away in 1985. Her estate recently trademarked her name. How does that impact me or my project?
Even though the person's dead,
Mm-hmm.
right? Remember, copyright lasts past the person's death. So copyright in any of their works are still in place. Also, there's something called right of publicity for famous people. And unlike right to privacy, which ends when you die because you're no longer alive, you don't need privacy, it's assumed. But right to publicity goes on past the person's life. So if any work you're doing trades on the public professional name of someone well known, then there are rights of publicity that can be protected or worked with. So when there's an estate and they've taken the time to trademark a name, know that they've decided that they are going to closely monitor use of that person's assets, creativity, likeness, image in the future, and you will probably need to contact the estate to get permission.
Lisa, we've got a couple of picky questions. What if my
Uh-oh.
character has a line from a song as his ringtone on his phone? What if it is a line from a poem that became a song? As far as I know, it does not matter what context you are citing. And if you write those words that were written by a song lyricist, you gotta pay to use them.
Yeah, you're okay. Here's the other thing I'm going to say. Somebody has to see it, right? And we all know visibility is an issue. So maybe nobody will ever see it and you'll get away with it, right? But if they see it, right, there's a problem. And you can use the song title. So you can say, right? I actually did this in one of my books. It's like a character in a recent short story I published in a charity anthology. The ringtone for her ex was the theme from Rocky. So I say, right, she knew who it was without picking up her phone because the theme from Rocky was blaring from, or Gonna Fly Now, the theme from Rocky was blaring through the phone. I can use the song title.
Mm-hmm. Mm-hmm.
I cannot use the lyrics from the song without permission. Now, another thing I've done as a way to get around it is I could paraphrase what the song is about. So I have a romance novel called Quarterback Casanova. And when I was thinking of a particular scene in the book, there's a song called Cowboy Casanova.
Mm-hmm.
And she talks about how, right, he's kind of this tall drink of water, but you needed to beware and whatever. So I don't use the slide from the song, but I mention that and I say, paraphrase what she says, and I say, change the blue eyes to brown, and that's your brother because she's talking to the character's brother. And that's where I got the title from. But I don't use the actual lyrics to the song, but I paraphrase it enough that if you know the song, you know what line I'm talking about, right?
Yeah, you evoke
So
the song. Yeah.
you evoke the song without using the actual lyrics to the song.
Right. So Patrice says, I have 3 chapbooks from Finishing Line Press that are now out of print, and I need to know what my rights are regarding future publication of individual poem and or chapbooks themselves. Do you have any advice about that?
You need to look at your contract. Contracts, contracts, contracts. If you have books with the prior publisher, prior corporation, your contract governs. Unfortunately, even when some of those places go out of business, you still may be tied to contract provisions, particularly if some other publisher bought their back catalog, or, and this is hard for a lot of people, even though the corporation itself may have gone out of business or the publisher, the person who owned it, depending on how they set that company up and what their organization documents were, one or more of the individuals associated with that may have been entitled to the assets of the company, even when it's been wrapped up. So you need to find that. Many times with the smaller presses, they blow up, they're gone, the people aren't going to organize them right. So you can take the risk to go out and reuse them, but you need to do your research. And also that I think it requires a professional. So I'm
Mhm.
going to say, find you a lawyer, right? It is something that I do on a small scale for writers that if you will send me your contract, I will read it. I will not give you legal advice unless you hire me as a lawyer, but I can at least explain to you what your contract says. And I've been really, really surprised by the language of some contracts. And there are some people who basically are prevented from using their works even after these people disappear.
Right. Right.
We have a fun question from Audrey. What if I had personal interactions with famous people? Can I use those scenes with the names of those famous people? Everyone wants me to write a book about it, but I hesitate. How do I write the stories of all the strange and weird interactions I have had with famous people without getting in trouble?
It's how you write up the scene, to be honest. If you actually met Brad Pitt one day or whatever, you can write in a book that I met Brad Pitt, right? The danger comes when people are writing about negative experiences. I want you to think back to what I said is when you're mentioning somebody and it's negative, they tend to be more upset about it than if it's positive. So if you're going to write about those experiences and those are just sort of like fun fan, like I ran into Keanu Reeves in the coffee shop, right? And you're talking about that and I gushed, you can do that. Most people's names alone are not enough to either have right of publicity or trademark rights as you're talking about them in text, right? Um, that said, talking about them inside a book or inside an article is different than marketing copy using that person's name as part of the marketing copy. Because now you're using the name to sell the book. And that's when we start getting into infringement territory. So you can't do that. And to help explain a little bit, people often ask me about the Olympics. The Olympics is a registered trademark. Olympian is a registered trademark. So people writing sports romances, if you want to talk about the Olympics inside the book, that's fine. But when the blurb on the outside of the book or your marketing or your Instagram post starts talking about an Olympic romance, come to the Olympics with these fictional characters, you actually do have some trademark infringement issues because you're using a registered trademark to sell your book, right, about the Olympics, even though it's a fictional game. And that, so those are the distinctions you have to make. Talking about it in your work versus using those famous names, those registered names to market your book. Those are two different things.
If someone creates a work of art, like an illustration or something, copyrights it themselves, and then uses AI to develop a derivative work like a video, is the derivative work still copyrightable? Let's say that Leonardo da Vinci is tired of hearing people debate about whether or not Mona Lisa is smiling. So he says, I am going to make a TikTok video in which she goes through my top favorite 50 facial expressions that I did not paint. Is that copyrightable?
The original works of authorship are protectable. Any aspect added by AI is not. So in this case, the Mona Lisa is still protected by copyright, right? But the current status of copyright law is anything additional added by AI is not. So if the expressions were all added by AI, the individual expressions are not, and they're, but in this case, it's like this weird thing. So if he copyrights them with the expression, someone can duplicate the expressions, but they can't duplicate the Mona Lisa with the expressions, right? So it kind of like doesn't help people because they can't infringe the Mona Lisa with the new facial features because the Mona Lisa is still yours if you were, right, if you were, say you were the artist. But when they register the copyright in those, you actually have to disclaim any portion created by AI. And if you were someone who wanted to do that to a work and you weren't the artist, you would have to get permission because you are absolutely correct. It's a derivative work of the original. So you can't do it without the artist's permission. And if you're the artist, what's protectable is your original creation, not anything you add by AI.
Fran asks, if a piece of my unfinished manuscript is used in someone else's book and they credit me, should I copyright that small section of my manuscript?
If they use, well, your entire manuscript is subject to copyright protection. So, like, you don't need to copyright small portions because everything you've written is protected by copyright. Where you may be concerned is there are some case laws where they looked at how much of a work was taken to determine the nature of the infringement or if the infringement was substantial enough to harm the market for the underlying work. But once you copyright the entire right article or whatever, you're protected. Or even if you don't file for copyright, remember you got copyright from the moment it's finished. Registration, I didn't say this earlier, so I'm going to add this. Registration is technically only necessary in the US to file a lawsuit. So it's you have copyright protection from the moment it's created in a tangible medium expression. You cannot file a lawsuit in the US unless you have a copyright registration to do so. But that registration or the automatic copyright covers the entire work, even tiny sections. So I'm not sure if I'm answering that question because I'm not clear on how the section would come in to play.
She says, MS, the manuscript is unfinished. Sorry, it's moved. This piece is intact and out there. Does that clarify anything?
So her piece is out there, but maybe she's thinking it's unfinished because she still wants to edit. So it's maybe a draft version of it and someone has already used it. And so with that, I will say your draft is also protected by copyright. Like it doesn't have to be what we would consider a final version because you know as writers we're rarely satisfied, right? We've always got a chance to add and revise. But a draft in a tangible medium of expression is protected by copyright, even though it's a draft. Then when you edit it, you have an edited version that's also protected by copyright. It doesn't matter that it's a draft version.
Right. Okay. We also have Diane who says, I'm working on a World War II story based on the father of a friend. There are a number of names of the deceased people that were teammates of this man. Can I use them or should I change them? These are deceased people.
They're deceased. You're using their names in a book?
A story based on the father of a friend.
If the story is not meant to be nonfiction, meaning it's not meant to actually cover that event as a historic event, I would say it makes more sense to change the name, in part because there are living relatives of those people around. And should they not like your spin on how you're going to tell this story, then you're affecting, to in their mind, you're affecting the memory of their loved ones. And I never understand the need for that if we're not talking about nonfiction meant to be an accurate account of the actual event.
Hmm. Yes.
We have a couple of questions about using institutions. Are places like university names trademarks? If I'm writing fiction about a sexual assault of a coach to an athlete in a particular sport, but I change the name of the governing body of that sport, like make up a fictitious governing body, can the organization sue me for damaging their reputation by inference?
If you have enough references in that everybody can tell who it is, even if you change the name, you do have a risk of that. Major institutions have legal departments, and a lot of universities are very mindful of protecting their name and their intellectual property. And yes, a lot of them file trademark protections for those.
There's a reason
So,
why on Law and Order, all of the murders happen at like Hudson University
right,
because they're
which
not going to
doesn't
name a real
exist,
one.
right? Because they made it up. So, particularly if you are using an assault that actually happened on that campus, and perhaps your book gives a negative connotation on how the administration handled it, I wouldn't go there. You want to use not only a fictional institution, but you want to change it enough that I can't tell what that institution is, even though you've changed the name.
Yeah.
Hmm.
Yeah.
Yeah.
Kat asks, what about essays? Should I copyright my essay before it is published online?
You can. Do you have to? No, it depends on your goal. Everything we've talked about depends on your goal. If you want to be able to file copyright infringement against people and get monetary damages, regardless of whether or not the infringement made them money, you'll need a copyright that's in existence before a copyright registration, rather, before the actual infringement occurs. That's US law. Um, so if you just want to stop people, you already have the copyright and you can send cease and desist letters and things like that without having an actual copyright registration. So it depends on your goal. What do you think you're going to do to protect your rights? And do you want just to stop people, or do you want to maximize potential monetary damages?
And also, if you're publishing it on your own site, you may want to copyright it. But if you're going to submit it for publication, the publication wants to copyright it rather than you copywriting it. They're not taking your rights, but they may look at it and go, why is this essay copywritten if they want to publish it with us? And that may strike some editors a little bit oddly. Lisa, we've had a number of questions about, can I name a brand? Can I name a famous person? Can you tell us briefly about nominative use?
Naming brands in books, um, again, is going to fall in that line of how are they named and protected. Most of our books will never be read by someone, right? But what happens if the wife of the general counsel of Coca-Cola happens to be a fan of your writing and picks up your book and sees Coca-Cola in a book where you're trashing Coca-Cola, right? Right? But having someone go to a restaurant and order a Coke, that's fine. That's nominative use, right? Um, but there are just several entities that be mindful that if they don't like the way they portray, they will sue. For instance, Disney. I, even if you think your right is legal, don't mess with the mouse, because the mouse will sue you whether or not they feel they have the actual copyright and they've got more money than most countries. So they will just bury you in litigation and you'll never win. It's not worth it. But if you want to say someone was driving a Ford, great. But if you're going to say somebody was driving a Ford and it was a piece of crap, yeah, I might not want to name Ford. You might want to make up the brand you're going to say it. You just have to be mindful that you don't know who's going to pick up that book, and negative use of a brand in any work just puts you at risk. Whether they're
I
right or
agree.
wrong, they can sue you and they will probably have more money than you.
We are coming near the end of our time, and we are going to leave you with our 3 top tips for what you can do today to be navigating the tricky world of AI, copyright, and plagiarism. Before we wrap up, we do want to say we hope you will join us again next month when we will be talking about Substack with our very own Rebecca Morrison and a panel of experts who are both making money on Substack and just enjoying it. Sharla, when should we join us next at Craft Talks?
Well, we have something happening tomorrow, but I wanted to let people know that we have a season pass for webinars. That's all weekly webinars until the end of the year, plus 3 office hours with Allison for less than the early bird price for each webinar. So if you want to know more, I'm going to add information in the chat. We also have all of July up. So if you want more information, see what else we're doing, we have workshops, seminars, and again, those weekly webinars, they're all up on our website. So I'll pop that information right now in the chat. What about you, Allison?
I've got Query Bootcamp coming up this weekend. Get $100 off and pitch to live agents with the code BRIDGE. We've also had Lisa drop her information. She does coaching for creatives at goingmogul.com/coaching, and that is also her consulting website. And you can find her books at lisarayne.com. That's RAYNE, like ray of powerful mofo sunshine, because Lisa is amazing. We want to leave you with our very top tips, things you can do today to be moving forward. Sharla, what is your top tip?
I mean, I'm no expert. I'm just a writer. I just would suggest for people to be curious, stay kind. And thank you, Lisa, for being the expert and for bringing your insights today. It's lovely.
Lisa, what's your top tip?
Ask yourself what your goal is. And whatever your goal is, it will drive your behavior towards your intellectual property. As I said earlier, if your goal is just to be able to send cease and desist letters and stop people from using your work, the automatic copyright is sufficient. If your goal is to stop people from infringing and get the best monetary damages possible, do consider registering your work in advance so that you can get statutory damages.
Excellent. I love that. And I want to say to everybody, in the long run, when we're worried about talking about people, when we're worried about quoting song lyrics, the things that protect us from legal action are also the things that help us stay kind and the things that make us better writers. Mary Carr has a great quote where she says, "I never called my parents alcoholics. I just showed the empty bottles." When we quote song lyrics, we're asking those lyrics to do shorthand for communicating an emotion that we have onto the page and hoping like heck the reader will feel that same emotion. Instead, write the emotion that you feel, that your characters are feeling. It is better writing than simply quoting a lyric. Showing people's behavior and letting the reader judge them is better writing than presenting your own assessment of their character. You guys are always a fantastic audience. We are so glad to have you in the Writers Bridge community. We'll see you again next month for Substack with Rebecca Morrison. Hi, Rebecca. And Lisa, thank you so much for sharing your time, your attention, and your expertise with us. Please, folks, please feel free to unmute yourselves for a joyful goodbye. And we'll see you on YouTube.
Thank you, everybody.
Thank
This was
you.
awesome.
Thank
you.
you.
This
Thank
was
you.
Thank you,
Bye.
Allison.
Thanks so
Bye-bye.
much.
Bye-bye.
Thank
You're
you.
allowed to talk.